employees may be honest, but if they are negligent, if they are not focused, they do not have commitment, the quality of their work leaves a lot to be desired. We will have problem in our operations. And so for those who are going to take the bar, I will share with you the cases, the leading cases. And for you who are now in the corporate world, you will be empowered with more knowledge about how the Supreme Court thinks about gross and habitual neglect of duty. In the past meetings, we have discussions about the fraud and breach of trust and LOTAC, loss of trust and confidence. We also had discussion on insubordination, willful disobedience to a lawful order given by a superior in relation to work, and serious misconduct. This is class number 22. This is the 22nd meeting, but we had other topics. It is in the last few weeks that we focus on termination of employment. We will start with the principle that as business owners, as management representing the company, we are granted by law an inherent authority to discipline as part of the right of the owners to manage their company. We can discipline our employees and even terminate their services based on the causes that are enumerated by law and analogous cases, and provided that we give them due process. So we have two things to think when we think of dismissal: the just cause, which is the substantive part, and the due process, which is the procedural part. Now, our topics is the substantive part. How do we know that a person is grossly and habitually negligent? How do we know that the behavior that has been manifested is sufficient to justify a decision like termination of employment? We have to remember that the employee has security of tenure. So we have to be very careful. Our decision should be based on legal principles. To be legal, no, I have a formula. Legal dismissal is equals to just cause or authorized cause plus due process. So if one of the elements is missing, we will have a problem with the labor arbiter and the NLRC. So the just causes, which are now in Article 297, used to be 282, can be classified only into the following. No? One is serious misconduct. We have to separate serious misconduct from insubordination, although in the enumeration, in paragraph A of Article 297 now, pinagsama yung serious misconduct at saka yung willful disobedience. We have to separate that because they are different. Serious misconduct is different from insubordination. So I separate insubordination. In fact, we had a meeting only about insubordination. And then today, we have gross and habitual neglect of duty. We are done with fraud at saka willful breach of trust. We will schedule crime against the person of the employer, immediate member of his family, or duly authorized representative. Those are assault by acts of assault or insult, uttering offensive words, highly defamatory or insulting words done by a subordinate against an employer. The word crime against the person for the law students do not understand in the context of the revised penal code, because if you say crime against person, you will refer to physical injuries, murder, homicide. No, crime against the person. Crimes against the person. In other words, the offended party is the employer. If the rank and file assaults an employer, that is a crime against the person of the employer, immediate member of the family of the employer, or duly authorized representative. So, our discussion will be about GANOD. GANOD is the word for gross and habitual neglect of duty. I am very fond of creating acronyms like LOTAC, loss of trust and confidence. Ako yung nag-umpisa noong SEBA, Sole and Exclusive Bargaining Agent. Tapos inadapt ng ibang mga authors. Kasi para na LLO, Legitimate Labor Organization, SEBA, Sole and Exclusive Bargaining Agent. Here in termination, I created this acronym for us to remember when we make decision or we take the bar. No? Serious misconduct, no? SERMIS, no? Serious misconduct. We are done with that, no? We have finished that. Insubordination, willful disobedience to a lawful order given by a superior in relation to what? You know, those who are going to take the bar, you have to say the entire thing. It's not sufficient to say willful disobedience. You have to say that the disobedience is in relation to a lawful order, and the one who gave that order is your superior, and the order is embraced within the scope of your work. That's why you are charged of insubordination. We are done with the LOTAC. We are now in GANOD. Then we will go to analogous cases. So I give you this formula. When you are confronted with a problem, whether the case is illegal or not, you have to ask, was there a just cause? Was there a due process? Because if your decision to terminate complies with the just cause and complies with the due process, you have no problem. Your problem will start from number 2, number 3, and number 4. When you do not have a just cause, or when you have a just cause but you did not follow the due process. And then when both are missing, that is the most problematic illegal dismissal. So it's very easy. Everything is very easy. So today we will study the different GANOD, like habitual absenteeism, chronic tardiness, damage to property through reckless imprudence. If your employees are so careless that by their act or by their omission, they have the proximate cause of the damage or loss to your company property is the negligence of the employee. That will fall under GANOD, no? Even if it is not habitual, even if the law says gross and habitual, the word "and," which is a conjunction, may be interpreted as "or," because if you always look for the two elements of gross and habitual, there are extreme cases, like if you have an employee 20 years in the service and he has not committed anything which is negligent or fraudulent. isang araw nakasunog siya ng isang building. Sinunog talaga, nasunog talaga niya. So that is gross, but that is not habitual. Kung if you interpret the law literally, hindi mo pa siya matanggal kasi hindi pa naman habitual, isang building lang ang nasunog niya. No, the law says that the law should be interpreted not by the letter that killeth, but by the spirit that giveth life. It should be the intention. When we say spirit of the law, the intention of the lawmaker is to empower the employer to do away with certain employees whose continued presence poses a danger to your business, no? Kaya minsan you really have to make a decision. It's a very hard decision to dismiss, no? Okay. Reckless driving resulting to damage, no? Damage to machine, tools, consistent, late, incomplete reports, below target in sales and performance, consistent below sales target. So, later on, I will discuss some cases about performance appraisal, below target. No? Again, I always show that. So when we talk of due process, you already master the 3 steps of due process. Wala na yung notice to explain na we should eradicate that from our mind because notice to explain is wrong. The first should be notice specifying the charge. We have to charge, no? And if you put a notice to explain in the notice to charge, it's okay. But the title is notice of specific charge. Then opportunity to be heard maybe in writing or in actual investigation. Then notice of decision. It's very easy to comply, no? So the Department of Labor issued Department Order 147-15 signed by Secretary Rosalinda Baldos in 2015, defining neglect. Neglect is repeated failure to perform one's duty. So what does this mean? It is very important that all employers should specify the duties of every employee because you cannot charge him of neglect of something that he is not in charge of. So the burden is on us. We have to present the job description that this is his duty. If it is not in the job description, it is in our memorandum, memo, circular, because the order of management is evolving. More and more are added as duties and responsibilities of the employees. But we have to document because the employees later on will tell a lie and say, I did not know that there is such a duty added to my job. No. So every time we add more duties to the job, we have to let him sign that there is a job enrichment. Although, of course, there is a principle in labor standards that says equal pay for equal work. If you make the work more complicated, in other words, you make it heavier, no, based on the principle of equal pay for equal work, you have to adjust the pay. But if it is just a minor addition, no, it does not entail additional cost, no, because we have to specify that the duties and responsibilities of every employee must be specific because repeated failure to perform that duty, and when there is a case of illegal dismissal, the burden is on the employer to show, is this his duty? The arbiter will ask, can you give me evidence that this is his duty? You cannot hide under the general statement of and such other matters as may be assigned to you from time to time. No? That cannot be invoked all the time. But if you add a very important, for instance, somebody resigns or retires, and you say instead of hiring a replacement, I will just add his duties to you, but I will increase your salary, no, because you will be in charge of you. I am enriching your job content, no. Ganon yun. So, but we have to document effective today that your job entails more duties and responsibilities, and you have to sign, you acknowledge that this is your job from now on. So this repeated failure to perform one's duties becomes neglect. And it depends upon the nature of the position. There are positions that are highly intricate and delicate. For instance, if you are operating a machine that is very expensive and you have a special training to do that, or you are assigned by the company to handle the executive payroll, and because of the highly confidential nature of your job, no, you should be very careful about it. So the more trust, the more responsibility, the lesser breach will justify a case of negligence. Because, you know, the word neglect or negligence is the negative word of diligence. And you will know in obligation and contract that every person is duty bound to observe the due diligence of a bonum pater familium, a good father of a family. That is the normal quantum or amount of diligence that you have to manifest. So if you fail if an employee fails to exercise that degree of diligence, then you are negligent. No? The absence of diligence is negligence. No? Yan. Yung ordinary prudent man. No? Prudence is proactiveness, the thoughtfulness of a normal person, no? The carefulness, the attention, the commitment, the focus. No, you have to be prudent. No? Otherwise, if you are imprudent, if you are reckless, you may cause damage on another. And in torts and damages, you may be you may be ordered to restitute for the damage that you have caused. Now, in employment, that is a breach of your obligation. When you commit negligence, you are absent habitually, that is a breach of contract, because the contract of employer and employer relationship is a contract whereby the employee obligates himself to work diligently. And therefore, to negate, to fail to do that is a breach of that obligation. So there must be a neglect of duty. And you can only neglect a duty if that is your duty. So, hindi tayo pwedeng mag-assume na naintindihan mo na yan, duty mo yan. But where is the document that indicates that it is his duty? No? So all these are in my book, and there are many principles here that duty of every employee is due diligence. You have to exercise care, caution, attention, prudence. No, these are all basic elements. So the absence of care is carelessness. No, caution, lack of caution, focus, lack of attention, imprudent. absence, prudence. When there is want or failure to exercise slight care, no, even the slightest care you did not, no. For instance, you know very well that you are drunk, you proceeded to operate the machine, you did not follow the protocol as stated in the brochure, thus you caused explosion, and that is gross negligence because there was want or absence or failure to exercise the slight care or diligence. So the grossness of negligence depends upon the amount of the value or the value of the thing that is lost. So the grossness of your act depends upon the consequences of your act. And also the number of the persons that you have injured, no? And also the rank of the offended party. No? If the offended party is of higher rank, then it will make your offense more grave, no? Because rank has its privilege. No? Habitual negligence is repeated failure, no, over a period of time. So if you ask me, attorney, gaano ba kadalas ang minsan? No, yung gaano kadalas ang minsan? So how many times must an employee be absent before we will call it habitual? My answer to you is that the labor code does not define for management. The labor code gives management the flexibility to define depending upon the nature of the position. No, every position has a different degree of expectation. If you are an operating room nurse, the expectation may be high. But if you are an ordinary janitor and you can be replaced anytime, no, maybe the degree of expectation may be lower than the ordinary or the more difficult positions. So, if you ask me, gaano ba kadalas ang minsan? So, ang sagot diyan, depende yan sa definition. Alam mo sa San Miguel, ang definition ng habitual absenteeism, pag meron kang 10 absences, no? 10 absences na unauthorized in a period of 6 months, that is already habitual. No? Unauthorized absences, ha? Pero pag authorized, so we can no longer blame the employee because you authorize him, and the authority should be granted prior to, no, except in emergency. So prior to your absence, you have to obtain authority or permission. Kasi pagka you have an application form for leave, iwan mo lang sa table ng presidente ng kumpanya. Nandyan yung presidente, si Miss Jarna Pistaño, presidente ng kumpanya yan. Iwan mo dan. Doon sa table ni Angel, yung anak niya. Wala, nagseminar. Do not assume na na-approve na yung leave mo just because you put the application. Remember, that is just an application. A leave must be approved. There is no authority yet just because you have submitted dapat ito ang i-clear ninyo sa mga empleyado ninyo, that when an employee submits, ito namang management, kung matagal mag-action, we have to put a deadline. Gawa natin ng protocol. If within 48 hours my application for leave is not acted, is not denied, it is now presumed to be approved. You must have that kind of policy, no? Kasi wala namang forever. Dapat merong answer, no? Huwag mong ibitin naman yung empleyado mo. So, pagka hindi ka sumagot within 48 hours, that means na-approve na yung leave. Yeah. I will go directly to the cases. Example ng case nung mga sample case of negligence. Okay, this is a case of a bank in Makati. A lady by the name of Fuentes, who was a teller, was counting the money. 200,000, tig 50,000 bawat bulk. No? 200,000 bilang niya. While she was counting, she was called by her superior. The protocol in the bank, according to their discipline, you have to put this money in the locker, you lock it, you masusian mo. What she did, iniwan niya on top of her table. What happened? When she came back, nagkulang na ng isang 50,000 pesos. Hindi na nalaman kung sinong nagnakaw. Alam mo, she was dismissed because of that. Even if she promised she will pay salary deduction, that's not enough because to pay is just to answer for the civil liability. But the administrative liability is not solved by paying. So, she was dismissed, and the dismissal was affirmed by the Supreme Court. Merong another, itong isang doktora sa, there is a school in Makati, a Catholic school, Colegio de Santa Rosa. And ito si Sister Marilyn Gustillo ang namumuno nito. And there is a Dr. Phyllis Rio, no? And she was hired to work in the school for only 4 hours every week. 4 na oras lang eh. Every week, ano lang trabahoin niya? She has to make sure that all the students are subjected to annual medical exam. Binabayaran ng estudyante yan eh. That sinisingil ng school yan sa mga parents. So, itong si Dr. Rio, na audit ito ng kanyang performance, nakita yung mga record ay topsy-turvy, and there is no indication kung anong percentage na ng mga estudyante ang na medical. Merong iba na dodoble ng medical, meron namang iba na hindi na medical. So tinanggal siya, and she filed a case, and she lost the case. Management won the case because the Supreme Court said that how can we trust a doctor who is not organized, no? Whose records are topsy-turvy. Especially now, pandemic tayo, kung meron tayong ganong doktor. 79 students of several classes or section were not given any medical examination. 9 students have medical records for school years where they were not yet enrolled. Ano ito? Ginawa-gawa lang nila itong record. So, sa madalit sabi, even a professional doctor can be held liable for gross and habitual neglect of duty. So, don't think that because you have a higher rank, you cannot be subjected to some disciplinary action. So we will now take up cases about gano due to habitual absenteeism, chronic tardiness, gano the employee negligence manifested by incompetence. Incompetence. Alam mo, when we talk of incompetence, this is also the fault of the employer. Why did you not test him properly when you recruited him? Because if an employee is incompetent, no? If he is guilty of incompetence, there is something wrong in your hiring system. Well, if you trained him already and everybody else have learned, but this person is still incompetent, that is the problem. No? For instance, you know, when computer was first introduced, that was the time I was in San Miguel Corporation. Now, can you imagine these old executives transitioning from the old Underwood typewriter, now going into computer? All the executives, managers were required to undergo training and others refused to. So they were retired. If you cannot cope with the trends of technology, you have to give way to the younger generation who are very techno-savvy. Ito, employees negligence causing damage to the employer. Meron ding employee negligence causing damage to the customer or the client. Meron ganon. Yung nurse na nagkamali, ang pasyente na problema. Meron nga ang doktor na nagkamali ng paglagay ng anesthesia. Then yung patient na naglakad, when he enters the hospital, he became comatose, naging vegetable because of the gross negligence of the doctor. So dapat ang mga doktor managot din. Kasi ang mamahal ng mga singil nila pagkatapos incompetent yung iba. Ganod, employee negligence manifested by poor performance. In other words, performance evaluation system. Now, this begs the question sa mga employers. Is your performance evaluation system really working? Do you have a clear, accurate performance evaluation system? Kasi how can you charge an employee of below performance, below par, when your performance system is not clear? The standards are not measurable. They are all subjective. They are not time-bound. No, they are not specific. You know, it's a science and an art how to make a performance evaluation system. You cannot charge your employee of poor performance when your evaluation system is not good. Yung mga sales quota in company engaged in sales, they require the salesman to be able to deliver the volumes of business that are compliant with the quota given to them. And consistently, they have failed to deliver 3 performance evaluation. They failed. That can be already ground for termination of employment. There are gross negligence that results to fraud or breach of trust. For instance, a certain bank, in a certain bank, because of the negligence of the bank officer, somebody was able to perpetuate a fraud costing 1.7 million pesos. This bank employee was not part of the syndicate. He was only negligent because he did not exercise the due diligence of examining and authenticating the document, whether they are genuine or they are fake, and the loan was approved, only to realize that the company applying for a loan is a non-existent company, fictitious company. In other words, the employee of the bank did not exercise the due diligence demanded by his position, even if he was not guilty of dishonesty. Loss of trust and confidence can also result because of negligence. Usually loss of trust pertains to property. Yung mga makakati ang kamay, nagnanakaw, nangungupit, malverse ng corporate fund, doon ang loss of trust. Pero if your negligence is so gross that it creates a big damage to the company, that can also be the cause of loss of trust and confidence, as I will illustrate. And lastly, the ultimate form of gross and habitual negligence is abandonment of duty. Yung mga empleyado bigla na lang nawala, tapos na yung lockdown, tapos na yung stricto nating mga protocols, inaalaw na mag-operate, wala nang danger, may mga sasakyan ang available, ayaw pa rin mag-report, no? And hindi na tumatawag sa opisina at hindi na sumasagot. Then all of a sudden, magpa-file ng kaso ng illegal dismissal. Meron na akong solusyon dyan. No? At this point in time, I will change my, meron akong another document for the cases. No? Iba ng document ang gagamitin ko. Meron akong separate document na related to the cases. It is just a pity that we do not have much time and we cannot entertain question, but you can, if you have a very important question, you can go to the chat box and ask your questions. And when I have time to answer it here, I can email it to you. Or I can send it by any other means. So we will start with the most prevalent form of ganod, which is habitual absenteeism and chronic tardiness. The word chronic comes from the root word chronos. Chronos is time. That's why Chronos is the god of time, because that is chronology. Doon ang gagaling yung chronos, chronology. So, pag chronic ang tardiness, sobra ng ilang beses na ito. No? Chronic na. We will start with a case entitled Challenge Shocks Corporation versus Court of Appeals, 2005 decision. Habitual absenteeism and tardiness, consisting of lack of initiative, diligence, discipline, which, according to the Supreme Court, exhibits the employee's deportment towards work. And the Supreme Court said, we find the penalty of dismissal from the service reasonable. Supreme Court na nagsabi niya na, the Supreme Court said, we find the penalty of dismissal reasonable and appropriate to the employee's infraction because her repeated negligence is not tolerable, neither should it merit the penalty of suspension only. Because the employee here was saying that, yes, I was negligent, but dismissal is too harsh because I have been connected with the company for so long. That is not acceptable. And who said that? It is the Supreme Court. Now, I'll tell you, those who own companies here now, be sure that the records of your HR are clear. Records of absenteeism, records of tardiness. I do not believe that every 2 years you have to erase these records, because how can you charge a person of habitual if you will erase his past offenses? There is a theory that a person should be allowed to reform, and to allow him to reform, you have to clean up his record as if he is a new person. Parang born again siya, nawala na yung kasalanan niya. But how the element of habituality requires evidence. Now, if you have that kind of policy, you can never dismiss an employee for habitual negligence because you erase. I do not recommend erasing. That is disadvantageous to the employee, to the employer. No? Kasi mga empleyado matatalino yan, i-schedule nila yung absences nila na hindi sila tatama doon sa maximum. Pag malapit na sa maximum sila, tigil sila. Then, after 2 years, erase. Then, start na naman sila. Kalukuhan yan. So here, the Supreme Court said, speaking through a lady justice, Inari Santiago, the employee here is a girl. She was habitually negligent, and the Supreme Court justice was a lady. The record of an employee is a relevant consideration. So, the best evidence here is the record. Now, if you are charged of illegal dismissal and we will prepare the position paper, what kind of attachment shall we put if you do not have a record because you have already erased it? The employee committed several infractions in the past, and despite the warnings and suspension, she continued to display a neglectful attitude towards her work. An employee's past misconduct and present behavior must be taken together in determining the proper imposable penalty. Taken together. So hindi tama yung wala na akong pakialam sa iyong nakaraan. Ang pakialaman ko na lang ay yung ngayon at ang bukas. Aba, hindi totoo yan. Dapat ungkatin pa rin ang nakaraan kasi ang batas nagsasabi ng habitual. And this is the totality of behavior rule. The totality of infraction or the number of violations committed during the period of employment shall be considered in determining the penalty. The offenses committed by him or by her should not be taken singly and separately, but in their totality. Fitness for continued employment cannot be compartmentalized into tight little cubicles of aspects of character, conduct, and ability, separate and independent of each other. It is the totality. No, you cannot isolate one act, but you have to lump all acts together. That will justify, the phrase, gross and habitual neglect of duty, as shown in the following acts. Lagay mo lahat ng kasalanan niya, no? So huwag niyong i-apply yung nasulat sa desiderata. Nabasa ba niyo yung desiderata? Sinabi, do not keep a record of wrongs. Do not keep a record of wrongs. Pero dito sa HR, you have to keep a record of both the right and the wrong. So you have to be balanced. When I was vice president of Pepsi Cola, 17 managers were reporting to me. 17. And I have 17 notebooks. 17 notebooks. And that notebook, we have the blue and the red. No, the blue is the good news, good things that he has done. And then the red are the areas where he missed the target, that he was out of line, that he violated the rules. And so when I met with him in a performance appraisal meeting, I have documents. Hindi yung memoryahin mo lang yung tao. No? Ako, magaling akong mag-keep ng records. Alam mo yung si Speaker Alan Velasco, si J. Lord Alan Velasco was my student in 1991 in UST. Pinakita ko pa sa kanya yung class record ko kung magkanong grado binigay ko sa kanya. Sabi ko, kung hindi kita binigyan ng grado na ito, hindi ka maging abogado. Kung hindi ka maging abogado, Hindi ka magiging congressman, hindi ka magiging speaker. So, niwala naman siya. So, pagka-record talaga, hindi niya ako matatalo dyan. Lahat ng anak ko, 5 anak ko, merong record ako. Kompleto akong notebook sa mga anak ko. Na lahat ng gasto ko sa lahat, bawat anak nilalagay ko doon sa record. Para pag may manligaw, sasabihin ko, ito, gastos ko. Kaya mo ba yan? Hindi na bumalik. No? Biro lang yan. Pero ang sinasabi ko, you have to keep records. You have to keep records because we are talking of gross and habitual neglect of duty. And if you confront your subordinate and say, alam mo, ikaw hindi kita mabigyan ng mataas na rating. Bakit? Kung kay negligent ka sa trabaho. That is a conclusion. Pero if I say, in a period of 12 months, you were absent 23 times and I have the dates. You were late 37 times and I have the date. That's not an opinion. Those are facts. And so my performance evaluation is based on facts. So ito sa PLDT naman, this is another case. Babae rin ito Amparo Balbastro. This girl was dismissed by PLDT because she was a telephone operator of PLDT. She was on a hold 3 times sa isang taon. And the employee was nag-sick leave siya June 25. Bumalik sila July 14 na. Nag-sick leave ng June 25, bumalik ng July 14. Ano ang sakit niya? Sore eyes. Ngayon, sore eyes, kailangan ganong katagal. Ang sabi ng Supreme Court, if she was really ill for such a long time, pati ang Supreme Court, nagdududa doon sa kanya. She would have already been confined in a hospital for treatment because PLDT has a standing agreement with various hospitals to provide medical assistance free of charge. Kasi sino ba may-ari ng PLDT? Di ba si Manny Pangilinan? Sino may-ari ng mga hospital? Cardinal Santos, Makati Med, Asian Hospital, lahat Manny Pangilinan. O Jarna, yung kaibigan natin si Attorney Pilar Almira, siya ng presidente ng Makati Med, kaya ikaw na rin ang mag-supply doon, no? So happy ka ngayon, no? Itong babaeng ito, she was sick, no? Medical records niya. Alam mo ang kaso dito, bakit siya tinanggal? Abuse of sick leave privileges. Take note, abuse of sick leave privileges. Previous infractions may be used as justification for an employee's dismissal. So hindi pwedeng sabihin na yung mga nakaraan niya, hindi na natin bilangin yun kasi she was already penalized for that. No. Kahit penalized na siya, pag sinabi natin ng habitual, counted pa rin yun. No? Mali yung Court of Appeals kasi sabi ng Court of Appeals, we should not rely on the previous absences in 1978 and in 1982. Pero ang sabi ng Supreme Court, assuming totoo yan, but in 1989 alone, she was on a hold for 3 times unauthorized. So that is enough, 3 times unauthorized a hold according to the Supreme Court. Because this position is very vital, the business is very vital, your absence therefore will create damage to the business. And even if the law says we have to be compassionate, compassion does not mean that we should destroy the business. No? The intent is to balance. Pero hindi ibig sabihin dahil mahirap ka, absent ka ng absent, patawarin ka na lang kay mahirap ka. No. You have to do your job because when you accept a job, that is a covenant and you are therefore violating the contract. That is a breach of contract. I don't know if our friends, I have friends from the academy that I invited like Sister Rosan Malilin of the University of St. Paul. Of course, si Dr. Crispy Velasco is UVian, pero meron akong in-invite presidente ng university. Ito kasi very important ito kasi Dr. Velasco sinabi dito, absence without leave in educational institution should not be taken lightly. Alam mo, Dr. Velasco, itong profesora sa University of Immaculate Conception, sa Davao ito eh. Ang madre dito is si Mother Asamta David, no? RBM. Tapos yung profesora, ang kanyang rank ay Associate Professor 2. Siya din ang union president. Sila nagtayo ng union dyan. Pero that is immaterial whether you are a union president or not. That does not mean na hindi ka matamaan ng disciplinary action. You are not exempted from disciplinary action just because you are a president. She was on a wall or a wall or whatever you call it, no? Because she went on a seminar from November 18 to 22. Nag-website development seminar siya sa Quezon City. Tapos pumunta sa Baguio, hindi nagpaalam sa madre. From January 28 to February 3, advanced paralegal training. Nag-aaral sila paano nila gambalain yung administrations, pamamagaytan ng paralegal. Okay lang yun sa madre. Basta magpaalam ka. Hindi ka nagpaalam eh. Absent without official leave. Alam mo ang suspension niya? For every AWOL, 6 months. So, 1 year yung suspension niya. Sabi, valid ba yan? O, Supreme Court nagsabi, valid eh. Walang batas sa labor code. Kayong kukuha ng bar. There is nothing in the labor code that says that suspension should be limited to 30 days. The suspension that is limited to 30 days is only preventive suspension. Yung hindi pa siya napatunayan guilty. Because his continued presence poses a danger to the life or property of the employer, limited to 30 days. Pero pag suspension na punitive, he was already found guilty or she was found guilty. 1 year. O, meron Pepsi Cola executive na suspension ng 1 year. Merong nurse sa Medical Center Manila who was suspended for 2 years. And there was a flight stewardess of PAL who was also suspended for 1 year. And the Supreme Court upheld the validity. Now, itong teacher na ito, arrogante din siguro ito. With due respect, I'm sorry to say that. Bakit? Sinabihan na siya ng madre, if you will just write a letter of apology, I will drop the charge. Ayaw niya. She does not want to apologize. Why? Is there something wrong for you to apologize to the administration for going on leave without official permission? Yan ba, mababawasan ba yung pagkaprofesora mo? Ang iyong dignidad mababawasan ba? Tanong natin kay Attorney Amistad. Ang ganda pala nito ni Attorney Amistad, ang ganda ng picture. Tanong mo kay Attorney Amistad, yung bang abogada, kung mag-apologize ka sa hindi abogada, nawawalan ka ba ng karat sa pagkatao mo? Ito, profesora na ito.
No,
yan.
USEC.
Yan o. Answer niya, no. Oh.
Yes, no, USEC.
Kita mo, apology is not something that will diminish your dignity. In fact, it will improve your, enhance your respectability. Kami mga abogado, pinagalitan kami ng judge dahil na-late kami. Apologize kami, huwag mo awayin yung judge. Never quarrel with your employer. Yan ang sabi ko, Ma'am Crispy Velasco. Ang sabi ko sa mga empleyado, huwag ninyong duraan ang langit. Sa Tagalog pa kasi maraming Tagalog nag-attend, mga madaghang dili ingon nato Daghang dili ingon nato nga apil sa seminar karon, mao na nga akong ipasabot. Sa Tagalog, huwag mong duraan ang langit. Sa Bisaya, ayaw gludi ang langit. Ngayon, ang madre nagsabi na, Ma'am, if you will just write a letter of apology, I will drop the charge. Oh, mamatigas siya, di sinuspend siya ng 6 months. Tapos, umulit pa siya, another 6 months. And that was upheld by the Supreme Court as a valid exercise of management prerogative. Kita mo? As a learning institution daw, as a learning institution, the university cannot be expected to take lightly absences without official leave, more so among its faculty members, even if they happen to be union officers. Kita mo, mong sabihin union officer ka, exempted ka sa company rules. Walang ganun. Dapat nga maging model kay. Ito, sa Mansion Printing Center, itong driver ito, si Diosdado Bitara Jr., kapangalan pa naman ng Chief Justice, Diosdado Bitara. Dati helper lang ito, kargador, ngayon naging driver na. Tapos ang daming absent, no? Alam mo yung mga printing press ito nagmamadali, panahong graduation, kailangan tapusin natin ito kasi marami kakasuhan tayo ng damages pag hindi natin matapos. Siya ayaw niyang umatid, no? Absences niya patong-patong. So, tinanggal siya. This attendance delinquencies may be characterized as habitual and sufficient justification to terminate the complainant's employment. Because even if the law is solicitous of the welfare of the employees, it must also protect the rights of the employer. Kita mo? No? Compassion and human consideration will be given to the employees, but it does not mean that if they violate the rules, we will not penalize them. We have the prerogative to impose discipline. Punta tayo dito sa Kwan. Ibang kasalanan naman. Employee negligence giving rise to the commission of fraud. Damage caused 40,000 pesos. 40,000 pesos lang yan. Ito, unahin natin 1.7 million. 1.7 million. China Banking Corporation. Ito si Victorino Cruz. Kung nakikinig siya ngayon sa akin, no? Hindi naman siya dishonest. He was only negligent. And he disregarded company rules, and he failed to exercise the due diligence that was demanded by his position to review the documents, no? And because of his failure to exercise the due diligence, the bank lost 1.7 million pesos. Kailangan pa bang isipin yun? Even if he has been with the bank for 21 years, the length of service, wala siyang matanggap kahit separation pay. The length of service is not a mitigating factor. Because if he suffered loss of his retirement, the bank also suffered so much because of his negligence. Kita mo? Ito, 40,000. Respondent Leonilio, babae din to. Together with Teresita Supnad, were implicated in intention to defraud the bank in the amount of 740,000 pesos. On the basis of the record, the evidence presented by the bank, Citibank, the arbitrator rendered a decision na the bank was not able to prove the guilt of the 3 employees, no? So the arbitrator decided in favor of the employees. But the bank went to the Supreme Court. If the bank was not able to prove dishonesty, the evidence pointed out that these employees were negligent. The evidence may not point out that they intended to defraud the bank, but the fact remains that the bank suffered tremendous losses, and that those losses can be attributed as the proximate cause, the negligence of these three bank employees. So their dismissal was considered legal. Ito, tapos na tayo. Ito si Bitara, Diosdado Bitara. Ito naman, puro bank ito eh. Habitual failure to enforce documentary requirements. Again, equitable bank. Again, the employee here was dismissed. The dismissal was affirmed as a valid exercise of management prerogative. Because he signed the transaction without the signature of the concerned client. You know, the bank has certain protocols as required by central bank regulations. And mga loan, pipirmahan mo, aprobahan mo ang loan, wala dyan sa harap mo yung applicant ng loan. And it turned out na fictitious yung borrower. O sino may kasalanan dito? Who was the author of the proximate omission that caused the damage? It was this person. So he was dismissed, and his dismissal was found as legal. Ito, 50,000. Ito yung sinabi ko, si Maria Linda Puentes. Ito yung sinabi ko kanina, teller, 200,000 binilang, 50,000 lang nawala. Buti nga, hindi ninakaw yung 200,000 eh. Tanggal siya doon. Ito naman, Genesis Transport. Driver na naman to. Ang daming problema natin sa driver, Ma'am Valerie. Sa mga driver talaga, matigas ang ulo dito eh. Bakit ba itong mga driver nagbibigay ng problema sa management to? Respondent Juan Taroy was hired by Genesis Transport as driver on commission basis. Even if he is on commission basis, there is employer-employee relationship. Alam mo, some people, akala nila pag commission or boundary, hindi yun empleyado. So hindi nila nire-report sa SSS. Yun ang mali. Because the commission or the boundary is just a manner of paying. But the fact remains that he is under your control. Pag nandoon yung element of compensation, control, at saka yung contract, the meeting of the minds, tatlo lang yun eh. Yung usual apat na elements, ginawa kong tatlo. Contract, compensation, control. Contract means there is a meeting of the minds. Even if there's no written agreement, contract is the meeting of the minds between the employer and the employee. I do that you may give. I do my job, you give me my salary. There is a meeting of the mind. And then the payment of the salary through boundary. And then control. In case of violation, subjected to discipline. Control. In fact, dismissal is the ultimate control. So, itong taong ito, accident naman ito, reckless driving resulting to accident. And after due investigation, there was evidence that the driver was at fault. He was violating traffic rules. He was presumed to be negligent because he was driving at a one-way road. He was opposing the traffic, and then his license has expired. Those are multiple violations, multiple negligence. Okay, dito tayo sa habitual failure to achieve performance target. In the pharma company, yung mga midrep, meron niyang mga sales quota. Alam mo dito sa Philippines why our medicines are very expensive. Because the salaries and benefits of the pharma industry employees are one of the highest in the Philippines. If you ask me, what is the highest paying job in the Philippines? What company is paying the highest salary? Pharma company. Because I have been a consultant of so many global pharma company. And I know when we negotiate the CBA, so many benefits na talagang spoiled ang mga pharma company. So ito, as a midrep, he has a quota. He must be able to deliver a certain volume of sales. And failing to achieve his plan of action or target objectives, he was sent to separate notices, charging him of negligence, and he was subjected to investigation. Then the panel investigating him recommended termination, and his services were terminated. He filed a case. The arbiter declared that he was illegally dismissed. The NLRC 4th Division, sa Cebu ito, 4th Division. Ito si Alan Gustilo, kuanto pag Gustilo, mga Ilonggo na apelyido ito. And 4th Division of NLRC is based in Cebu. And the 4th Division affirmed the decision of the arbiter that the dismissal was illegal and the company is ordered to reinstate. The appellate court reversed the NLRC. The appellate court, the Court of Appeals, which is also based in Cebu, said that he cannot be reinstated. So instead of paying reinstatement, instead of reinstating him, he should be paid separation pay in lieu of reinstatement. But the Supreme Court reversed all their decision. Tingnan mo listen to me. The arbiter said illegal ang dismissal. The NLRC said illegal ang dismissal. The Court of Appeal said illegal ang dismissal. Alam mo ang sabi sa Supreme Court? No. Management was correct in terminating his services. Kaya maganda ang chance natin sa Supreme Court You have a better chance in the Supreme Court because the Supreme Court understands the predicament of management, having to bear as burden these employees who are creating problems to the company. So, zero siya. Walang separation pay. Walang reinstatement, walang separation pay. Zero. Ito, private school teachers negligence. Alam mo ito, Ma'am Crispy.
Yes, attorney.
Alam mo ito si Corazon Tagyam. Doon ito sa school sa Holy Spirit, no? Sa Holy Spirit. Meron akong pinsan na madre, si Sister Helen, in-invite ko. Iwan ko kung nakapasok si Sister Helen. Ito, nagkaroon ng activity ang mga pupils, no? And inaalaw naman ito, binigyan ng approval ng administration. They will have after the examination, gusto nilang mag-happy-happy ang mga grade 5. Isang section lang mga ito, grade 5 Emerald. And the class president wrote a letter to the principal requesting for permission to hold a year-end celebration at the school ground. Doon sila matulog. Tapos mag-night swimming sila. While the pupils were swimming, dalawa nag-sneak out. So na-worried ngayon itong teacher. Kawawa naman ito si Corazon Tagyam. Naawa ako dito eh. Hinanap niya yung yung mga bata na umiskapo kasi pananagutan niya ito eh. At while she was looking for these two lost elements, yung naiwan na si Shara May na drowned, na lumos, namatay. That the pupil died inside the school campus. Na ito na ngayon, maraming problema na ngayon kasi ang lahat ng sisi ay nandoon kay Corazon Tagyam. Bantayan mo yung mahigit na 40 mga bata na parang nakawala sa turil na ang ingay-ingay nila, takbo ng takbo, yung iba na nawawala, tapos isang teacher lang. Sa madalit sabi dito, Dr. Velasco, I don't know if you think that this is fair decision. She was dismissed, and not only that, pinailan pa siya ng kaso ng criminal case, reckless imprudence resulting to the death of that girl. So, and the Supreme Court approved the dismissal. Wala lang, hindi lang ito, wala dito ang kaso ng kriminal. This is only the labor aspect. And management was right in terminating the services of a teacher. Can you imagine, kung ako ang teacher niyan, I will not agree na ako lang isa magbabantay ng itong 40 mga anggugulong mga estudyante. Tapos ng finals na nagkakagulo sila, mga 5 years old. This is really, you know, I have a module on all criminal cases involving universities. Alam mo dito, Ma'am Crispy, hindi ka pa siguro sinilang sa mundo. Nagkaroon ng problema diyan sa San Jose. Kasi ang city fiscal natin, si City Fiscal Jose Amadora, taga Dumanog yun eh, mistiso yun. Kamag-anak din ni Pabling Garcia yun. Magkakamag-anak yun. Alam mo, yung anak niya, nag-submit lang ng kanyang project doon sa San Jose kasi tapos na yung semester eh. Nag-submit, binaril sa loob ng San Jose. Pinailan ng kaso yung San Jose at nagkaroon ng kuanyan, that is a leading case in torts and damages. No? And what is the liability of the institution if there is such an event that will happen inside your campus? No? Nabanggit ko lang yun. It was Corazon Tagyam's responsibility as class advisor, sabi ng Supreme Court, to supervise her class in all activities sanctioned by the school. Alam mo, Ma'am Crispy, yung mga papipirma-pirma ng waiver, baliwala yun eh. Halimbawa, mag-outing, tapos papipirmahin ng waiver. Kahit pumirma ka ng waiver, yung parents pumirma ng waiver, that waiver is null and void. The parents can still file a case of damages against the university. Yung mga may nangyari yan, may isang universities doon sa Tugigaraw, Cagayan, hindi ko lang babanggitin ang pangalan. Ha? Meron ding nalunod. Kasi itong nalunod na ito yung walang waiver. No, lahat may waiver. Yung administrator nagbantay doon sa school bus. Sakay na sila. Yung isa walang waiver, umiiyak. Nagmamakaawa. Naawa yung teacher yata yun. Pinasakay. Yun pa ang yung wala pang waiver, yun pa ang na disgrasya. Kaya nagkaroon ng kaso. Kaya alam mo, ikaw, ma'am, you are in charge of student affairs. Mahirap na trabaho yan. Lahat ng affairs, pakikialaman mo. Alam mo ba kung sino ang may affair dyan? Trabaho mo yan, babantayan mo yung may mga affair. No? Kasi student affairs. Mabigat yung trabaho ni Ma'am Crispy. When the negligence is not habitual and the employer has contributory negligence, ito magandang kaso ito. Merong isang hospital na ang tawagin lang natin sa pangalang Medical Center Manila. Itago lang natin sa tunay niyang pangalan na Medical Center Manila. At itong si Edna De Castro, isang nurse. Ngayon, merong isang pasyente na 81-year-old. Doon merong private room. Meron naman siyang bantay. Tumawag yung 81-year-old kasi gusto niyang abutin yung bedpan. Tumawag doon sa nurse station. Nagkataon ang nurses, ang daming trabaho, merong tawag sa operating room, merong tawag, ilang kwarto yung siniservisyohan ito ni Edna Castro. Hindi niya, pinapunta na lang niya yung isang she asked somebody else to go there instead of the nurse. And when that person arrived, wala na, nahulog na sa bed yung matanda. And the family of the patient filed a case of damages against the hospital. And Edna Castro became the sacrificial lamb. Siya ngayon yung napag-initan. No? Pero pagdating sa Supreme Court, sa labor arbiter, panalo si Edna. Sabi, walang kasalanan yan. Si NLRC, ni-reverse ng arbiter. Sabi ng NLRC, may kasalanan si Edna. Sa Court of Appeals naman, ibinalik yung desisyon ng arbiter. Walang kasalanan na naman. Pagdating sa Supreme Court, alam mong desisyon ng Supreme Court? May pagkukulang si Edna, pero dismissal is too harsh because of the number of patients assigned to her is physically impossible. Kaya ang kanyang dismissal ay reduced only to suspension of 1 year. So yung kanyang back wages na good for 8 years na sahod niya, babayaran ng Medical Center Manila minus 1 year. Yun lang matanggap niya kasi there is such thing as contributory negligence. What is the meaning of that? Management was also negligent. Why? Because management did not provide enough number of nurses proportionate to the number of patients. How can De Castro be expected to be answering all rooms, calling at the same time? Ano ito, private room, ito may nagbabantay na ito. Bakit hindi man makaabot yung nagbabantay doon sa bedpan? Tatawag pa sa nurse, pagkatapos pagdating doon, nahulog na. Yan ang mga disgrasya sa buhay. Termination of employment cannot be done based on gross and habitual negligence when there is no performance standards. Okay, ito ngayon. How can you terminate ito doon? Nangyari ito sa Saudi Arabia. Isang OFW pinauwi ng amo on the ground that mababa ang performance. Nag-file ng kaso. Pagdating sa Supreme Court, he won because of only one thing. How can you fault your employee for negligence if you have not defined the nature of the work, the volume of the work, you have no key performance indicator, you have no key results area and key performance indicator. Yung performance evaluation is not based on standards that are specific, measurable, objective, time-bound. So, panalo siya sa kaso niya. Pero kasi overseas employment ito, ang kanyang back wages is limited to 24 months. Kung nakatrabaho na siya ng 3 months, 24 minus 3. Yan ang ibayad sa kanyang sahod. All those 21 months salary should be paid. Sino magbabayad? Ang employer nasa Saudi. Di yung recruiter. That is precisely the reason why we require a recruiter, because under the Magna Carta of Overseas Worker, Republic Act 8042, as amended by Republic Act 10022, all the faults of the principal, the one answerable is the recruiter. Precisely that is the reason why we require recruiter to be involved, because if we do not do that, there is no protection for OFW. We cannot acquire jurisdiction over the person of the employers abroad. There must be somebody here in the Philippines who will answer for all the liabilities that the agent is bound by the acts of the principal. Not just the principal bound by the acts of the agent. Ito, ay Ma'am Crispy, ito nangyari ito sa Cebu dito sa tinatawag na Ayala Center sa Cebu. Ito si Juliet Alcoseba at saka si Flor de Linda Araw-Araw. Empleyado ito ng isang butik na ang pangalan Kulas Ideas and Creation. And ang may-ari nito itong Maningo, mag-asawang Maningo. Itong dalawang trabahante was accused by the owners of gross negligence. Nawala daw yung 48,000 pesos. But lumalabas sa hearing na kaya nagalit ang may-ari dito dahil ininspeksyon ng DOLE. At nung ininspeksyon ng DOLE, ang mga Ayala Center, nalaman yung mga sahod ay wala sa minimum, walang bayad ng mga service incentive leave, yung mga benepisyo ng mga holiday pay. So, parang lumalabas na retaliation itong pag-charge sa kanila. Allegedly na kung talagang nawalan ka ng 48,000 pesos, bakit wala man lang na blatter na nawala? Anong basis? Walang formal documentation. It's just the words of the owner. And because of that, nakarating sa Supreme Court ito. Kaso na ito. And you cannot fault these two employees for negligence. Negligent daw sila kaya nawala yung pera. Because in the first place, you have not even proved na minawala talaga. So how can you prove negligence when there was no evidence of the body, the corpus delicti? There was not even proof that something is lost. So mahirap yun Probationary employee. If you terminate the services of a probationary employee, it is very elementary that when you hire a probationary employee, ladies and gentlemen, on the day that he is hired, not tomorrow, you have to inform him of the reasonable standards by which his performance will be evaluated. And those standards should be measurable and time-bound. Failing in which, if the employer fails, then he has no standard and he cannot say he cannot conclude that he did not pass the probationary period because he has no measurement standard. Paano mo ako sabihin na tinimbang ka ngunit kulang? Hindi naman malinaw kung anong batayan. Ano bang hinahanap mo sa akin para makapasa ako? What kind of performance? What kind of behavior? What kind of quota? What kind of expectation? You have not put that in writing and you have to make it known to me at the time of the engagement. Yan ang problema dito. Nangyari pa naman ito sa Mitsubishi. Kaya panalo ang empleyado dito eh. Ito, balik na naman tayo sa absenteeism. Management should make sure that dismissal based on habitual absenteeism must also be gross in the sense that the frequency and the number of incidents. So, kaya nga sinasabi ko yung gaano kadalas ang minsan eh. Because sa unang kaso ng PLDT, management won. Because it was really proven that in a period of 1 year, there were 3 absence without official leave. But here in this case, also involving PLDT, in the case of Joey Teves, management here failed to establish that the frequency exceeded the threshold. No? Then you will ask, sir, what is the threshold? Again, I will answer. Management has the prerogative to establish the threshold, meaning limit the number of absences per month, per quarter, or the entire year. You have the employees should not exceed the number of allowable absenteeism. And if he exceeds that, that will constitute as gross and habitual neglect of duty. Because all these things, ladies and gentlemen, are very vague and hazy. And if it is vague and hazy, do not blame the law. That only means that the law gives you the freedom to define. The freedom to define is vested on the company. In other words, the law respects the company in the exercise of its judgment because that's part of management prerogatives. Kung ang lahat na lang ang gobyerno, ang batas ang magawa ng standards, so wala ka ng freedom to manage your business. You are under dictation by management in everything. No? So you should feel happy if you are from management. Sabi mo, bakit naman very big itong batas na ito? Pag sinabing gross and habitual, sabi ng habitual, ilang beses ba gagawin para maging habitual? Define it according to the nature of your business, according to the position, whether it is vital and essential and highly delicate, and then you put a matrix and make it clear to him. When you hire him, and then you remind him, keep on reminding him so that he will follow the path. Ganoon yun. Trabaho ng management. When there are more serious offenses other than gross and habitual neglect of duty, the more serious offenses should be the main charge. So, ang ibig sabihin dito, ladies and gentlemen, if an employee is guilty of fraud and at the same time of negligence, the more serious there is fraud because it is dishonesty. So you have to focus on the more serious. Do not focus on the negligence because the law is more strict when it comes to dishonesty. Sometimes the law, the arbiter and the NLRC are very liberal when it comes to absenteeism. They do not understand the implication to the business. But when it comes to dishonesty, everybody is strict about dishonesty. So, you know, we talk of loss of confidence. Ano bang pangalan ng company, Neil, na pinuntahan natin sa Clark na nagle-lecture tayo doon? Yung nagmamanufacture sila ng mga branded na mga long sleeve.
Luwentay, attorney.
Luwentay. Alam mo Neil, nasusulat yan sa SCRA. Ang Vice President ng Luwentay, isang lady, HR, Vice President for HR. She was dismissed and the dismissal was approved by the Supreme Court as legal. Anong kasalanan niya? Kasalanan niya, lahat ng advice niya tungkol sa labor problem ay mali. Wala siyang knowledge sa labor code. Hindi siya nagsiseminar, hindi siya nagbabasa ng libro. So ang mga advice niya mali. Nagreklamo yung ibang mga department. Ano bang klase yung HR natin? Lahat ng desisyon natin mali kasi advice niya mali. So because of that, she was dismissed. Pero binasa ko, mali yung the way it was worded because hindi mo pwedeng kasuhan ng loss of trust and confidence because of lack of knowledge of the labor law. That cannot be justified. No? If in law, when you teach labor law, you cannot teach students saying that when an executive does not know labor law, the charge there is loss of trust and confidence. No. What I'm saying is we have to put the proper charge when we subject an employee to an administrative disciplinary action. Otherwise, it would be illegal dismissal for the wrong charge. Happily na lang nanalo ang company doon eh. No? Na-mention ko lang yun eh. A simple and one-time negligence may justify termination of employment due to the serious and far-reaching consequence and damages. Ito yung sinasabi ko na 20 years employee walang kasalanan. Isang araw nagkasala ng kunti, nakasunog ng isang building. So, isa lang, no? Pero you don't have to be habitual if that is pareho nang nangyari dito sa Samar Electric. Pero ang problema lang dito sa Samar Electric, tatlo silang kinasuhan, to si Raquisa, si Balasbas at saka si Martinez, dahil nagkaroon ng brownout sa buong Samar for 4 months. Sila ang binlame, no? Bakit nag-brown out ang Samar for 4 months sa Melco? Nagreklamo ang mga subscriber ng Samar Electric Cooperative 2. And ang sabi ng arbiter, tama namang tanggalin kayo, pero pati kami wala kaming kuryente. Pati ang NLRC ni-reverse yung desisyon. Sinabi that the dismissal is illegal. And dumating sa Supreme Court, wala pang Court of Appeals noon, diretso sa Supreme Court. Yes, they have maybe they have some negligence, but the management was not able to pinpoint what really was the series of acts that they did not do or they have failed to perform that caused the brownout. Because, you know, it may be not the fault of the employee, but the fault of the machine. No? It may be mechanical defect. Parang kuan yan eh. Parang crash ng eroplano eh. We cannot always blame the pilot. It may not be human error. And the Supreme Court said here, it's very difficult to approve this dismissal because it is just a conclusion. Just because they were the one in charge, you are already concluding that their action or their lack of action was the cause of the brownout. You should put in your documents, really, in your position paper and in your submissions to the court, what action did these three people fail to perform, which was the proximate cause of the brownout. You cannot say na brownout, so kasalanan nilang tatlo. You cannot do that. You have to link. You have to establish the link by submitting evidence that will show that this is their duty. They have failed to perform the duty, and the failure to perform the duty was the cause of the brownout. And why did it take 4 months? No? Why did it take 4 months for the entire island of Samar to be out of electrical connection because of this? No? Nabayaran pa ng separation pay ito eh. One time or isolated incident, even if attributed to the employee, cannot be a justifiable cause for termination. Ito yung sa St. Luke's Medical Center, merong isang foreigner na patient, si Justin Tibon, no? Na attending to his 3-year-old daughter, no, in the hospital. Alam mo naman, St. Luke's ito, high profile ito mga. Ang trabaho nito si Estilito Notaryo, hindi ito abogado, hindi ito notaryo publiko. Kung ito, siya ang in charge doon sa mga CCTV. And itong mga nagmo-monitor siya ng mga kamera kasi pag nag-monitor ka talaga ng kamera, makikita mo yung mga nagnanakaw ng pasyente kasi when you have in a high-class hospital, there are many valuables, and some people pretending to be visitors, they will just enter the room and get the bag or whatever there. So this person who is a foreigner lost a valuable, and because of that, he was asking for the CCTV record so that he could trace, no? And there was none because on that day, a notario who was in charge of that did not do his job properly. And because of that, he was dismissed. Only because of that. Now, the moral of the story here is this. If you are the employer, do not be pressured by an external people or customer. Madali ka mag-decision just to please a customer. You will immediately dismiss a person without even considering all the circumstances, assuming that he was really negligent. But this is the first time that he is negligent. No? Ang masama dito, nakita later on yung nawala eh. So, the alleged damage was actually recovered. So, and yet the employee was already dismissed. So, the Supreme Court said that the dismissal was illegal. Okay, ito, St. Paul ito. Ewan ko, nandito ba si Sister Rosan o Sister Sally? Hindi ko malaman eh. Ito sa St. Paul College, Quezon City. Nung araw, college pa yun, hindi pa yan university. I was a member of the board of that, board of trustee ako dyan eh. Ito si Sister Lilia Teres Tolentino. Ito na ngayon ang superior eh, provincial eh. Dati siya yung presidente doon. Tapos ang principal si Sister Bernadette, pati si Sister Sara Manapol, no? Ang dalawang mag-asawa, si Michael at saka si Cynthia Ancheta, pareho silang Probationary Employee Faculty member. And they always failed to submit the requirements. As faculty, marami silang dapat isubmit. Meron silang mga report na dapat isubmit. Lagi silang late. Tapos pag-report sa eskwelahan, lagi silang late. So, nakikita ng mga madre yan. Kasi St. Paul is a very well-managed institution. Para sa akin, yan ang one of the best sa mga eskwelahan na nakita ko. Kasi is very orderly, alaga lahat ng mga estudyante doon. Tapos itong mga teacher na ito, dalawang mag-asawa, kulang sa efficiency ito, kulang sa, lagi silang late eh. So tinanggal sila. Wala magagawa ang madre, tinanggal sila. Nag-file sila ng kaso, nanalo sila sa arbiter, panalo yung madre. No? Tapos nag-file sa NLRC, panalo pa rin ang St. Paul. Tapos pagdating sa Court of Appeals, ganun din. Hanggang sa Supreme Court, panalo pa rin ang madre dito. Probationary empleyado lang kayo, hindi kayo nagko-comply ng mga requirements, lagi kayong late, di tama lang na matanggal kayo. Yan ang sinabi doon. When dismissal is valid when the gross negligence is coupled with fraud. Dapat fraud ito coupled with gross negligence because fraud is the greater offense. More than 800,000 pesos. Caltex, sa Cebu ito, Ma'am Crispy. Alam mo dyan sa Caltex, sa Lapu-Lapu City, meron diyang, di ba, merong mga depo na lalagyan ng mga gasolina galing sa Maynila, di-deliver dyan. Tapos inaudit ito. This person by the name of Mr. Valenzuela was audited by head office of Caltex. Shortage yung kanyang gasolina, hindi niya ma-account worth 825,000 pesos. And he was charged of negligence. Kasi mahirap patunayan yung fraud. Negligence lang. And the dismissal, file siya ng kaso sa arbiter kasi tinanggal siya. And the labor arbiter decided in favor of the complainant, saying that the complainant, the labor arbiter held judgment is hereby rendered dismissing the claim. Dinismiss pala yung claim niya for illegal dismissal. But the NLRC, again, bakit ba hindi magkasundo itong NLRC at arbiter? The NLRC always reversed the arbiter and declared that the employee was illegally dismissed. And then the Court of Appeals naman, pabor naman sa management. Sa labor arbiter, pabor sa management. The NLRC, pabor sa empleyado. Sa Court of Appeals naman, balik naman yung pabor sa management. Ano pagdating sa Supreme Court? Evidence overwhelmingly shows that Mr. Valenzuela was indeed guilty of habitual and gross neglect of his duties. Buti nga, negligence lang ang kinuhaan sa kanya, hindi fraud eh. Pero hindi mo ma-account yung 800,000 pesos. Ang inventory ng gasolina, kumpara doon sa sales, merong lapse na nawala na ganong ka-amount. Negligence ba yun? Negligence ba yun na nawawalan ka ng gasolina? Ay, hindi ko masabi yung negligence na yun. Ito sa Associated Bank. A bank appraiser's negligence due to the huge disparity in appraisal of properties. Alam nyo yung mga bangko kasi pag nag-loan ka, ipapapraise yung property. Pag nag-appraise siya, naniniwala siya sa interview lang, hindi siya nag-check sa assessor's office. Hindi siya nag-check doon sa assessor's office para malaman ano ba ang prevailing market value dito sa area na ito. Malalaman mo yan kung pumunta ka sa city assessor's office. Hindi siya nagpupunta. Naniniwala siya, mag-interview siya ng mga standby dyan sa tabi-tabi. Magkano bang bilihan ng lupa dito? Ganun lang ang style niya. Di natanggal siya. Tanggal niya, okay sa Supreme Court yung pagkatanggal sa kanya. Ito si Rene Balyao sa West Negros College. Ang daming problema ito sa buhay. Meron na siyang kasong gross negligence, meron pang fraud. Pagkatapos na aresto pa siya for drug involvement. Nako. Ito, dinala sa NLRC sa Cebu. The labor arbiter decided in his favor. The NLRC affirmed the arbiter. Buti naman. The Court of Appeals held that the petitioner was validly dismissed. Ang Court of Appeals naman ngayon ang nag-disagree. And the Supreme Court agreed with the Court of Appeals. Paano mo i-reinstate yung taong ganun? May kasalanan, may gross and habitual negligence, merong fraud, meron pang involvement in drugs. Okay, itong manager ng pharma company ay nagkasakit ito, 1 year siya nagbakasyon sa Davao. After 1 year, pinauwi na sa Maynila. Kasi tapos na, may fit to work na siya. Ayaw niya mag-report. Gusto lang niya sa Davao. Inisyuhan siya ng warning. Ayaw niya mag-report. Gusto lang niya sa Davao. Tinanggal siya. And his salary was very high. He filed a case, malaki yung award sa kanya, umabot ng mga 4 million with damages. Pero pagdating Supreme Court, zero. Zero siya. As manager, you should exemplify the behavior of a good employee. You have to comply with policy. Binigyan ka na ng 1 year with salary, bakasyon with pay. Tapos ngayon, after 1 year, fit to work ka na, ayaw mo pang bumalik. Dapat ka lang tanggalin. So, ladies and gentlemen, it's already 8 o'clock and I have covered a lot of cases. I hope that you learned from the engagement tonight. Huwag muna kayong umalis. Magbukas muna kayo ng mga bintana ninyo kasi mag-picture taking tayo. By the way, ang request ko lang sa inyo, kasi libre naman ito, mag-subscribe na lang kayo sa aking YouTube channel. Kasi pag nag-subscribe kayo, you can get a copy of this video. Binibidyo ito eh. Lahat ng video, mga sobra na, mga 22, 23 video na ang na-upload. So, makuha niyo lahat yon, magagamit ninyo yon, and mag-subscribe kayo sa YouTube channel ko. I-type lang ninyo yung USEC JBJ. Marami pa kayo makukuha. No? At yun lang ang hinihingi ko sa inyo. I thank you for coming tonight. I hope, Ma'am Prispe at saka Din Wagas, magklase ba tayo next meeting araw ng patay?
Dili lang tayo magklase next meeting, attorney. Sa sunod na lang.
Ikaw
agad ra ko nimo.
Ikaw manggigamhanan, no? Di man ta makabisita sa patay ron, ang mga patay may mabisita nato. Mag-uwan lang ta, mag-andam lang ta kalag-kalag. Okay, so Maraming salamat, Ma'am Grace. Si
Okay.
Ma'am Nancy at saka yung iba ko in-invite kung nakarating ba yon. Attorney Panilagaw, magandang gabi.
Good evening, USEC. Thank you, USEC.
Pati si Miss Aurora Swasula, taga-Congress, nandito. Ang dami natin ngayon, umabot tayo ng 80 kanina. Umabot tayo ng 80 kanina. Buksan ninyo yung bintana nyo. Ikaw, Pidito, hindi ka nagbubukas ng bintana, hindi ka makikita. Paano mag-picture taking tayo? Mag-stop share na ako ha, para mag-picture taking tayo. Okay? Yan, Ma'am Nancy.
Hi,
Please ko
Panyera.
rin si Ma'am Nancy, parang bagong paligo lang eh.
Sabihin ninyo.
Thank you. Sir. Thank you.
All right. 1, 2, 3, smile.
Si Aldana, magbukas ka, Mr. Aldana.
One more. 1, 2, 3, smile. Alright. Last page. Ganyan lang. Last page, okay. Another one. 1, 2, 3. Smile. Alright. Thank you very much, everyone.
Thank you.
Thank you po.
Thank you.
Thank you, attorney.
Thank you, attorney.
Thank
Thank you.
Thank you.
Thank you, attorney.
you. Thank you.
Thank you.
Attorney Shia.
Yusek, amping diha, Yusek.
Jimenez.
Thank you so much, Yusek. Thank you, Yusek.
Amping Yusek.
Thank you. Thank you.
Ngalag-kalag na lang ko sa inyo.
Thank you, attorney.
Yeah.
Mga lagkalag.
Salamat sa tanan.
Good night, good night.
Bye.
Good night.
Thank you.
Thank you, Doc Velasco.
Good night.
Yeah, thank you.
Salamat sa inyo.
Good night.
Thank you, attorney.
Thank you, everybody.
Thank you, everyone.
Thank you so much.
Kain na tayo eh.
Thank you. Thank you,
Thank you, USEC.
Thank you, Panyera. Dimo, Panyera Shea, Panyera
Po,
May.
Yusek Liwag, Jimenez. Thank you po, Attorney Wagas.
You're welcome po. See you po next week.
See you po next week,
Thank you, everyone.
November 1. Thank
Ma'am
you.
Aida, baka after November 1 na po.
Opo.
A week
Sige po.
after next po. Opo. Sige po.
Sige po. Thank you.
Thank you. Good night, everyone. Thank you, Ma'am Michelle. Thank you, Doc Cora.
Thank you, ma'am. Attendance ko, ma'am.
Yes, Ma'am. Yes, Doc. Thank you, Sir Mark.
Thank you, Attorney Wagas.
Thank you,
Thank you.
El.
Thank you, Dean. Thank you, Wagas.
You're welcome, Sir Mark. Thank you, Sir Mark. Ako na nang i-end. Bye-bye. See you.
Bye, ma'am.